To recap quickly and deal with some counter-arguments put to me yesterday, or which my learned friend may seek to rely on in reply, it's common ground that the statutory purpose is not to take out of the standard rate all supplies that come within the social policy. See my learned friend's position that rolling news does not qualify for the zero rate. Another example is the decision to repeal the group relating to news services, such as those supplied by Reuters. My learned friend cannot say in reply that this was on the basis that the group was subsumed into Group 3, as such news services do not meet my learned friend's own definition of newspapers. Another example was the microfilm, that it was never zero rated, even though it existed in 72 and would contain the content of books or newspapers. It may be said that many people using microfilm were taxable persons that could claim the VAT back as input tax, but that would not be the position in all cases.
Well, that's irrelevant anyway, really, isn't it? Whether they can claim it back. The question is, was it or was it not zero rated?
Yes. We say further that there's no discernible statutory purpose to take out of the standard rate all supplies that have the same content as those that were zero rated in 75, but which take a modern form. The examples I gave yesterday are the fact that the UK never acted to apply an EU reduced rate to book content on CD-ROMs or USB sticks. My learned friend can't say that there was any assumption those were already caught by the zero rate. It was clear that they'd always been subject to the full standard rate by HMRC. The final
what do you say the purpose is of distinguishing between digital and print editions? You don't say, as I understand it, the fact that the digital edition was new is a bar, because you accept that new products can be included. So what is the material distinction, apart from the fact that one you can read on a screen and the other you can hold in your hand? I mean, why should that make a difference for tax purposes?
If I could frame my answer in this way, I don't know, I can speculate. So possibly Parliament thought will provide the minimum necessary. You have access to VAT-free printed newspapers. On anything more modern, we'll have the tax. The point is, my learned friend is also speculating. He says Parliament wouldn't care about medium, and I say that that's not right. But your lordships don't have to identify what Parliament's reasons were. You have to consider, what do we know was the statutory purpose here, and how do we apply that? And my point is that all we know, rather than speculation, is that there was no statutory purpose to zero rate everything that came within the social policy, common ground, see rolling news. And we should also know that there is no statutory purpose to zero rate all supplies that have the same content as the past zero rated supplies, CD books, CD-ROM books, and maps. And on maps...
Sorry, can I just press you on
yes.
the CD-ROM point?
Yes.
Could you just elaborate on what you're saying about that development?
So since 2009, the EU has provided permission to the member states to reduce rate books or book content on CD-ROMs, USB sticks, and so on. It's been clear since 2009, from the moment such supplies emerged, that the UK applies a standard rate. So it would have been from 2009 something like between 15 and 20%. So in all those years, although the UK knew that it could benefit the social policy by reduce rating these, bringing the tax down to 5%, it didn't act to do so. My learned friend can't say, oh, well, that's because it took the position that they were already in, because HMRC has clear guidelines and they've always been taxed at the full standard rate. Nor can it be said against me But Parliament never acted to make the newspapers provisions say expressly printed newspapers, to which my answer is that's never been an issue. The first court to say newspapers can include digital services was the upper tribunal in our case. By then, it was too late to change the past by legislation, and the 2018 directive was already in, pursuant to which the UK could decide its position going forward.
I entirely take your point that not everything that promotes literacy is within the exception has to be a newspaper. But I don't. The question then is it a newspaper or not? And how do you decide that question, if not by attributing some rational purpose to Parliament in delineating the concept?
I'll come on to that. How do you decide the meaning of newspaper? But the short answer is not through purpose. You start with the meaning and you look to statutory purpose to guide you if needed, but the statutory purpose here can't help you.
Well, I can see that meaning, insofar as there is a single ordinary meaning, takes you home, but I would have thought, perhaps you dispute this, that when you come to the electronic version, you might say that's a newspaper, or you might say it's not a newspaper, and then you have to, as a matter of speech. If I said, do you read the Times, and you said no, and I later found out you read it, or do you read a newspaper, and you say no, and I later find out you read the PDF online, I wouldn't think you've given me a very honest answer. So if you say it's not a newspaper online, then what's the criterion? Just to say it's not a physical thing, well, why does that matter?
My Lord, yes, and I'm not trying to avoid answering the question because it's a central question, but my submissions will answer it, I hope, step by step.
Fair enough.
Because one has to ask, what was a newspaper in 1975? What were the criteria then? What are the new criteria my learned friend supports? And so I want to take it step by step for that reason, if I may.
Absolutely. But anyway, you know what's in my mind.
Yes, and do come...
Can I just take you back to the CD-ROM answer? Because
yes.
I just wanted to come back. So what is the present position with regard
the standard... Sorry.
With regard to CD-ROMs and so on at this moment in time?
Standard rated. The 2018 directive gave permission to extend the zero rate to electronically supplied services. CD-ROM books are not electronically supplied services. They're digital, but they're not electronically supplied. They come on a physical format like a CD-ROM or a USB stick. So it's
presumably Mr. Peacock's possible response to that might be, well, that's because they're already covered.
Yes, and I hope I anticipated that, to say it's clear that the UK HMRC at least makes clear that they're not covered.
Well,
rightly or wrongly.
That's HMRC's view, but it hasn't been tested in court, has it?
Absolutely, and I'm not trying to rely on HMRC's view being right. The point I'm making is, as it is HMRC's view, it can't be said against me that the UK government didn't bother to reduce rate these things because it thought they were already in. That's the point I'm making. It was clear to Parliament that HMRC for the last 13 years considers that these are standard rated. It's always had the option, or since 2009, to reduce rate them, and it hasn't done so. So I'm not relying on the point that HMRC's view is right.
You're building on the point you made yesterday that the boundaries of zero rating are fairly granular. They're not based on mega policy considerations.
Yes, and we see that discrimination being made in, for example, CD-ROMs. And the other example yesterday, just to deal with a possible counter-argument, is maps. It's true that the 2018 directive did not permit zero rating of supplies consisting predominantly of video content. We don't say this would necessarily have excluded electronically supplied navigation maps, the kind that simply show the user as a dot moving on a screen is not necessarily predominantly video, but in any event, it's clear that entirely static electronically supplied maps were not zero-rated in 2010, even though their content would be the same as the printed maps zero-rated in 75. So we say no assumption.
So the Ordnance Survey map that you can get up on your iPhone is standard rated?
Yes, my learned junior tried to buy one the other day and was charged, well, he didn't buy it in the end, but that came up. It's clear that's the 2020 position extends the zero rate to electronically supplied items 1 to 3, not, I think it's item 5 maps. So decision made despite the content being the same. Now, to return to my Lord Legate's question, what's Parliament's purpose there? I don't need to answer that question. I just need to show that Parliament can and has made such decisions, presumably to benefit from the taxation. My learned friend, what I'm trying to show is that my learned friend can't, as in the embryo case, appeal to this notion that Parliament couldn't possibly want to discriminate here by showing you Parliament, of course, does discriminate in taxation matters.
I can see that would be a good answer if Parliament had said printed newspapers and there was some argument that that was discriminatory and contrary to principles of equal treatment. Then you could say, well, I don't need to show there's a reason, but taxation can take a reasonable compromise can be made in taxation, and this is the one that Parliament has made. But we're not faced with that. We're faced with a question of whether the concept does or doesn't include, is or is not included, limited to printed copies. And we have to make that judgment. And there, at the moment, I can't see any other rational means of doing it than by reference to whether there could reasonably be a reason to make a difference.
Well, I think we better let you develop your submission in the order that you seek to do so.
Yes, and just a very short answer. In 1975, no one needed to say printed newspapers because newspapers, by saying newspapers, the only thing that anyone could mean is printed physical objects.
Yes. And what was enacted in 1972 was known to be a transitional provision because it was implementing the second directive
Yes.
in advance of our joining the European community.
And of course, we were going to reach at some point total harmonisation, which
And,
hasn't
and
happened
thereafter we have the standstill. So we can't interpret this devoid from EU law.
yet. No, and I'll come on to EU.
You'll be coming on to that, but I think we should let you develop your submission.
I'm grateful, my Lord. So there can be no assumption that it follows from the fact that a provision zero rates a supply that has a particular content. There must be a statutory purpose to zero rate all supplies that have the same content irrespective of medium. The only discernible statutory purpose is to zero rate those supplies picked out, and it should be common ground that the meaning of newspaper in 75 could only have been that it is a physical object containing curated journalistic content. My learned friend can't say, you've just picked out one element, and that I equally can say it's the curated journalistic content. My definition covers both aspects of the meaning of newspapers in 1975. And my Lord Legate put to me yesterday that doesn't meaning always depend on function? And I responded by reference to the robotic dog and the e-dog, saying, well, function would get that wrong because you'd end up thinking these were dogs. To give a sort of to adjust my answer a little bit, sometimes function can't help. What is the function of an embryo? But an even better answer, I think, is that function can only typically give a partial meaning. It's not that function is irrelevant or always irrelevant. In colour offset, HMRC said, where the contenders were objects, it sought to argue on the basis of function and said, diaries, blank diaries, don't function as books because they're not designed to be read or looked at. So I don't object in principle to bringing function into a meaning. So one can say newspapers have the function of updating readers on current affairs. What I insist on is that that is only part of the meaning.
would it be of assistance to us to identify for us the characteristics of a newspaper that you say were material to members of the public who are interested in accessing them as of 1975, or whichever particular date you would like to take as your earliest date? What are the features of a newspaper?
First and foremost, a physical object.
Yeah.
Secondly, my learned friend's element, journalistic, curated, periodic content. And I'm happy to add a function there to inform the public on current affairs. But I say no correct meaning of newspapers in 1975 could omit that very basic, it's a physical object meaning.
If you said to
Characteristics.
a person in your family, have you read the newspaper, they would be contemplating a physical object.
In 1975, certainly.
Yes.
That was the point you made yesterday about a folded paper.
Yes.
If you said, could you please get me a newspaper, you'd be asking for the physical object.
Yes.
You'd be contemplating taking the physical object on the train or wherever.
Necessarily so.
Yes.
And of course, that's not the end of the matter, because your lordships have to give consideration to the always speaking doctrine, which, as I said yesterday, we don't oppose in principle, but we do say, in giving any updating construction, you have to show that the modern contender comes within the characteristics I've just outlined that existed in 1975. In general, cases applying the always speaking doctrine state that the meaning from 1975 in our case doesn't change. It's just that there may be a modern application of that meaning. And to give your lordships the reference for that, it's said in Quenterville, paragraph 9, at Authorities, page 705. My Lord Legate said it in ZYN, at paragraph 42, Authorities, page 663. And it was said in Fitzpatrick, Authorities, page 532 at C, and page 543 at B.
Sorry, could you just give me those last two again, please?
Fitzpatrick, Authorities, page 532 at C, and page 543 at B.
Thank you.
And we say the meaning of newspapers includes that it is necessarily a physical object. Another point commonly made in these cases is to ask whether Parliament has used a wide and flexible term. Now, the term family, considered in Fitzpatrick, was said repeatedly to be a loose, flexible and wide term. If I could just again give you, your lordships, the references. Page 528E, page 534B, page 535F, page 538H, and page 547G. And in Fitzpatrick, there was also, of course, an appeal to purpose. The purpose of the statute was to protect those who shared their life in a stable and permanent relationship with the tenant, and there could be no rational basis to limit that to heterosexual couples. The key characteristics of family were, of course, shared by those in same-sex relationships. See, for example, page 537B.
Yes, I have to say, this notion of whether a flexible term has been used strikes me as not particularly helpful, because we know one can have all sorts of much more specific terms, like embryo, that have been given wider meanings. So it becomes a circular discussion, does it not, as to what is a flexible term and what isn't?
My Lord, there may be cases which show that there is a sort of hard line, but in my submission, you can see clear-cut differences. Family, from the 1920 Act onwards, there have been debates in the case law. Does it include stepchildren? Does it include de facto adopted children? Does it include partners? Does it include cousins if you're living with them but not sharing lives? I mean, it's understood that it's always been a bit of an unclear type, or wide or flexible term. Similarly to document. The Grant case, my learned friend didn't take you to it, but it regarded the question whether a tape recording was a document, and it was said there that cinema, photographs, coins, frescoes have all been seen to be documents, very wide term. Newspaper, of course we're having a debate as to whether it refers only to printed newspapers or to both printed newspapers and the digital news services, but it's hardly a wide term as family is.
Nor is books, which has been interpreted to include microfiche. I mean, I would accept that it makes the task perhaps easier in applying always speaking if you've got a term like reasonableness or family or something that is inherently wide-ranging, but I don't think it precludes always speaking if one's actually got a very narrow term like embryo or book. So I'm not sure it's going to get us anywhere, is my only counter-argument to what you're saying.
I appreciate that, and I'm not saying that it's decisive, but I'm simply pointing to, in the interpretative role, note that we don't have that kind of term here. The key guidelines for the application of the always speaking doctrine were those set out in the Royal College of Nursing that Quenterville said were authoritative, and my learned friend took you to them yesterday. That's authorities page 706 at paragraph 10. These guidelines say consider the genus of fact question, which we discussed yesterday, and ask if the modern contender is the same genus of fact as the state of affairs that existed in, for our purposes, 1975. And we say that the genus in 75 necessarily included that newspapers were physical objects. Your lordships will recall the example at paragraph 9 of Quenterville. A new species of dog would be a dog, same genus, but a cat is not a dog. The guidelines also ask whether the modern contender is of the same kind and dimension. We say the modern contender here is an entirely different kind and dimension to newspapers in 75. They're not physical at all. They require a device. One has no access at all to the news content without a device, internet access. They can link, or at least most of them can link into other content. They give access to archived editions. They can contain video and audio content. They have search functions. They can be updated immediately in the event of breaking news. It's true that the FTT found the printed newspapers and digital news services were similar from a consumer's viewpoint, but that is not the right question when seeking to identify whether the two are in the same genus of fact or kind and dimension. I made the point yesterday that a user, a consumer of a robotic dog or an e-dog, may find these as valuable as a dog, but they are not the same genus of fact or the same kind and dimension.
And it's right to say, isn't it, that we have to look at the whole range of examples that have been given of digital newspapers, ranging from the PDF facsimile through to the editions of a newspaper that one can get on one's iPhone that are, at least these days, often updated. It is that whole category that we must look at. Nobody's suggesting that we hive off, let's say, the PDF facsimile edition. I don't think, are they?
My learned friend hinted yesterday that it's open to this court to say it's clear that the smartphone website and tablet editions are not zero-rated newspapers because of all the links to archived material, links to video or audio content and that sort of thing. but that it may be that your lordships decide that the e-reader, which has, as I understand it, only a search function, might be a zero-rated newspaper.
Are we equipped to carry out that sort of exercise of dividing this up into chunks?
My
We're
lords, I
not a
don't...
fact-finding body normally.
Sorry, my
We're
lord.
not normally a fact-finding body.
Well, my learned friend will say that you have the facts from the FTT about what each of these supplies consisted of.
And that would be enough to make these decisions, would it?
Well, my lords, this is my learned friend's position, and he can respond and reply. My own position is that none of them can come into the key characteristics of newspapers in 1975. They're all electronically delivered, or electronically supplied services.
But on
Even
top
the PDF reader.
But on top of that, is it your submission that we can't proceed to divide this up now? Or do you say that we can look at these and consider separately a PDF version from the interlinked news updated versions?
I don't think I say that you can't, I just don't invite you to. And to digress for a moment, I just want to deal with the fact that the FTT considered that the digital news services were not physical objects and therefore were out, and the Court of Appeal agreed with that position. The fact that they weren't physical objects meant that they were out. The Court of Appeal's position is in paragraph 69, key documents, page 87. The point the Court of Appeal were making was that it's not just that the newspapers in 75 were physical objects. All the goods in Group 3 were physical objects.
Which paragraph did you say?
It's page 87 of the key documents, and it's paragraph 69.
69. Okay.
It's a long paragraph, my lord, and I just want to take you to a couple of points in it rather than the whole thing. My learned friend said that printed music was referred to, in looking at the group, the context, if you like, my learned friend said printed music was referred to as printed music, but the term printed newspapers wasn't used. And we say that's, of course, because non-printed music existed in 1975, but in 1975 there was no need to say printed newspapers. Newspapers, by definition, were printed objects. And one particular point my learned friend did not deal with, I think, is in relation to Note 2 to Group 3 that was added in 2011 to deal with the anti-avoidance Telewest issue. The Court of Appeal's position is at the end of paragraph 69, the last 10 or so lines. But essentially the point the Court of Appeal makes there is Note 2 prevents a splitting of a supply of goods in items 1 to 6 with a supply of services such as the TV service and Telewest. The Court of Appeal says if Parliament considered that items 1 to 6 could themselves contain services, there's no rational explanation as to why they would not have referred in 2011 to services being split with services in Note 2. And to respond to my learned friend's point that one cannot look to future notes in 2011 to identify meaning enacted prior to that note, my Lord Legate explained in the ZYN case that this was sometimes permissible to explain an ambiguous term. We say newspapers is not ambiguous, but my learned friend says it could refer to goods or services, or goods and services. And for your note, it's page 667, Authorities, paragraph 59 in ZYN. And one minor point on note 1A, which covered the loan of physical objects by libraries. although that's technically a service in EU law, because to be a supply of a good, ownership has to pass, of course, it was still a physical supply, a supply of a physical object. So just watching the pen. So returning to the Quenterville Royal College guidelines, these also ask whether the nature of the statute being interpreted is liberal or restrictive. We say the zero rating provisions are necessarily restrictive. I'll expand on that when I get to Part 3 and the EU constraints. But for now, it's enough to note that it is common ground that any valid interpretation cannot be one that extends the scope of the provision beyond its 1975 borders. Not even for reasons relating to fiscal neutrality. And we say that necessarily makes the provision restrictive rather than liberal in nature. The final aspect of the Royal College of Nursing guidelines is that they ask whether there can be detected a clear statutory purpose which can only be fulfilled if the extension is made. So not only were the CNR embryos held to meet the genus of fact, kind and dimension questions, it was considered there could be no rational basis in the statutory purpose for excluding CNR embryos from the protection of the Act. We say in our case, the submissions, on the basis of the submissions I've already made, it simply cannot be said that the statutory purpose of the zero rating provision would be frustrated if the digital news services were not covered. I don't understand my learned friend even to claim such a position, nor can it be said that there is no rational basis to exclude them from the provision. In taxation, unlike in relation to the protection of embryos, there's always a statutory basis in play, another statutory purpose in play to raise taxation for the public good. And I just, under this always speaking doctrine, want to look at one final case, which I think is the one that my learned friend relies on the most. It is a pre-Quenterville case that suggests that the very meaning of a term, not just its application, may be updated. And that's the Victor Chandler case, which is Authorities, page 1054. My Lords, just to summarise what the case was about, the relevant provision made it an offence for offshore bookmakers to issue, circulate or distribute advertisements or other documents in the UK, which invited bets, because such offshore bookmakers would not be subject to betting duty. Importantly, at paragraph 7, page 1056, first 4 lines, the Court of Appeal identifies the purpose of the statute as being to protect the revenue and protect domestic bookmakers from unfair competition from offshore bookmakers. And the question in that case was whether the offshore bookmaker committed an offence in circumstances when it had arranged for advertisements to be available for viewing in the UK on teletext. And the problem was that it had been accepted that document was a wide term. It caught not only film, tape recordings, but also information stored on computer databases. That counted as a document. And the concern was that what was happening in this case was one was sending information from one database offshore to another database in the UK, but the information itself was not a document. As Lord Chadwick explained, what one was doing was transmitting electronic impulses in a language which the recipient computer could read. The sender, in effect, was creating a document in the recipient database. However, their lordships thought that this would count as issuing or distributing a document, and Lord Chadwick noted, people speak today of sending a document. In such cases, for your note, it's page 1067, paragraph 45, C to D. In other words, his lordship relied on updating the language of the provision, looking at the use of document and sending a document in the modern context, and said this was within the true intention of Parliament, the statutory purpose. Similarly, Sir Richard Scott, conscious of the fact that this was a penal statute, said it had to be a very clear case that the new situation fell within the statutory purpose. See paragraph 32, page 1062. But his lordship concluded at page 1063, and this is important, the statutory purpose would be seriously undermined if the teletext adverts were not caught.
Where do we see that?
It's page 1063. And I'll tell you which letter.
Oh, yes, I see letter D.
Just letter D. The ability of section 91B to achieve its purpose of protecting the revenue and protecting domestic bookmakers from unfair competition by offshore bookmakers will be seriously undermined. Just as the protection of embryos would be seriously undermined if it didn't cover CNR embryos. And in our case, I don't think that's something I've done. And in our case, we say there are two reasons why this approach can't be taken. First, a more minor one. My learned friend claims that in the claim period, the term newspapers was commonly used to describe the digital news services. There's no finding in the FTT to that effect. And my learned friend's own submissions to the FTT in 2017, so just at the end of the claim period, was that the digital news services were termed either digital newspapers or online newspapers. And I won't ask you to turn it up, but the references for that are the key documents bundle, page 144, paragraph 149, page 147, paragraph 170, page 152, paragraph 191. More importantly, and this is the bigger point, there's no basis in our case for considering the statutory purpose would be seriously undermined if digital news services were not zero-rated. And we don't need to go to it, but my learned friend mentioned yesterday the Harrier case decided in the first-tier tribunal. That case decided that photo books, i.e. objects made of leaves, fitting the colour offset meaning of books, were zero rated, even though they didn't exist back in 75. That doesn't trouble me at all. They met all the key characteristics of books that existed in 75.
Sorry, why do you say it wouldn't seriously undermine the statutory purpose if digital newspapers were zero rated?
Because the statutory purpose that I've supported doesn't hold that everything that has the same content as the printed version ought to be zero rated. Back to the CD-ROM books, the maps examples that I've given. If I could turn then to part 3 of my submissions and the EU law constraints. So the EU constraints apply here, and that is common ground, unlike the domestic always speaking cases that weren't related to EU law. And the key restrictions are that your Lordship's interpretation must not extend the scope of the newspaper provision beyond its 75 borders, and your Lordship's interpretation must qualify as a strict interpretation. My lords were taken to the key case of Talca Beach yesterday by my learned friend. And just to remind your Lordships, the problem that arose there was in EU law, there is a rule that a single composite supply, that is, a single supply made up of 2 or more elements, is characterized by the principal element. And in Talca, the principal element would have been the zero-rated caravan, not the standard-rated contents of the caravan. And under that EU law rule, the single supply of caravan with contents would have resulted in the contents also being zero-rated. That was the problem. The CJU's answer to the problem was that the EU rule on characterizing a single supply on the basis of a single rate had to be ignored in order to avoid a non-zero rated element, the caravan's contents, coming into the zero rate. And to highlight the strength of the EU's position on restricting zero rates, in the case of EU exemptions, which are EU exemptions, not the national derogations such as the zero rates, in the case of EU exemptions, the CJEU does not take the position that one ignores the single supply, single rate rule. And for your note, that is clear from paragraph 24 of the CJU's judgment, which says it doesn't matter about the cases we see in paragraph 15, and if one looks at paragraph 15, there are 2 cases there, CPP and Henriksen, which are exemption cases. And we see the explanation for that position from the Advocate General at page 424 of the authorities bundle, paragraph 42.
Sorry, could you give me the page again?
Yes, it's page 424.
Thank you.
I'm just going to turn it up. Paragraph 42, the Advocate General says, finally, although it must be conceded that the court has accepted that tax exemptions for the principal element of a composite supply may be extended to ancillary supplies connected with it, nevertheless, as the UK government rightly submits, those cases concerned exemptions under Article 13 of the 6th Directive, therefore exemptions enshrined in the scheme of the directive, in the application of which the right of deduction is excluded. In contrast, the national exceptions under Article 28 lie outside the harmonised framework. They are not directed at the same objectives as the exemptions provided for in the directive itself and differ in form from those exemptions. Consequently, in those cases, it's necessary to take particular care that the exceptions are not extended. Now, the key passages on not extending the scope are at page 427, paragraphs 19 to 23, that my learned friend took you to yesterday. But I just set out the key propositions that I take from those. First, including a supply in the zero rate that was expressly excluded in 91 would extend the scope. See paragraph 21. We say, in effect, the digital news services were expressly excluded because newspaper in 1975, 1991 meant printed newspaper. Secondly, the purpose of the zero rating permission in Article 28(2)A, which is now, of course, Article 110 of the PVD, the standstill clause, was to prevent hardship that would follow from the abolition of zero rates that were enjoyed prior to the coming into force of the 6th Directive. That is paragraph 22 of Talika. We say this is critical. Your Lordships will recall the 2nd Directive permitted zero rating for a social purpose and for the benefit of the final consumer. But the 6th Directive did not permit any new zero rating or extension of zero rating, even for a social purpose and even for the benefit of the final consumer. It required.
The hardship of which the court spoke, is that the hardship to the final consumer that can be extended? Yes.
Yes, that they wake up one day, they go to get their newspaper from the local shop and
more
abolished.
Yes, I see. But you say that it's one thing to protect them against change, against the alteration of the status quo. It's something else to extend beyond the status quo.
And it's an extension, I mean, is the key issue. So the 6th Directive did not permit new zero rates or extension of existing zero rates. It required member states to bring the national position in line with the 6th Directive, save that Article 28, the standstill clause, permitted zero rates that were already in place to be maintained. But note, the already in place in 1977, when the 6th Directive was enacted, meant already in place for 2 years, i.e. from 1975 to the 1st of January 1978. The end of 75, sorry, to the 1st of January 78. So it had to be in place for 2 years. Under the new Principal VAT Directive, enacted in 2006, the protected zero rates had to be in place for 15 years, going back to 1991. So it is not just zero rates that could be maintained, it was long established zero rates that would be tolerated because their removal might cause social hardship. And my Lord Hodge has my point. No hardship could ensue in relation to digital news services that had never been enjoyed by UK consumers.
Could you just help me, please, with one point that I'm still wrestling with? As I understand it, you don't go so far as to suggest that the always speaking doctrine is excluded in the context of this case, but nevertheless we should apply some stricter approach to its interpretation. Where in this spectrum are we supposed to draw the line between the application of the traditional always speaking doctrine and the restrictive approach that you say we should adopt to interpretation here?
Yes. My Lord, I say that the approach that you must take is to consider whether the new contender comes within the key characteristics, the criteria of the supply in 75.
But is that not the same as the always speaking doctrine?
It's quite similar because, as I've just explained, genus of fact, kind and dimension is a sort of similar idea, and in the Fitzpatrick family case, it was said, look for the key characteristics of family. So it's quite similar, but my position is that if my learned friend somehow gets past the always speaking doctrine, that if your lordships are on his side on the always speaking doctrine, he still has to then confront an EU barrier, which is not exactly like the Quenterville criteria. It says you cannot extend the scope, and that is common ground.
You can't extend the scope unless?
You can't extend the scope, full stop, and that is common ground.
Yeah.
And I will take you to two cases which I hope spell out more clearly what it is to extend the scope. But the short answer is, look at the criteria that were in place in 75. What are the new criteria that my learned friend relies on? And I think my learned friend suggested yesterday that your lordships have free rein, if you like, because we're discussing the meaning of newspaper and national provision, and your interpretation will always be about newspapers. That's not the CJU's approach. And I'll take you to a case in a moment where the national provision related to cars, but I think it's Austria, didn't have free rein to decide what it thought cars meant, or to update its meaning of cars. The CJU had a very simple position. Was it a car pre-standstill? Is it a car now under your new criteria? And if there's a difference, it's an extension of scope.
Yes.
Does that at least help for the moment until I take you to the actual case?
Thank you.
Just a related question. Does the EU have any principle of always speaking in interpreting EU legislation?
Not that I could find, my lord. Not that I could find, but I obviously looked quite carefully in this context, and I saw no sign of it. But our position isn't extreme in the sense that a smoothie can, of course, still be food, even though smoothies didn't exist in 1972. But they meet all the characteristics. They're just the new instance of...
Well, food is a generic term, isn't it? I mean,
food is a generic term.
It's like saying an electronic device. Well,
Yes.
electronic device might encompass all sorts of new innovations. But you say newspaper doesn't because of the physical characteristics.
I suppose the reason I ask is that we're always brought up to believe that the teleological approach, i.e. purposive interpretation in Europe, was in a sense more liberal than the approach in the UK. It might seem a bit odd if the domestic approach to interpretation of domestic legislation is somehow more liberal than the European approach.
2 points on that. The purpose in play, as far as the EU is concerned, is that zero rates, everything should be abolished We have a little saving for now for the long-established zero rates, but we're in the process of getting rid of them. So different purpose in play. And the other point I keep coming back to is my learned friend can't appeal to purpose. It's not that I'm against a purposive interpretation in any way, but my learned friend hasn't established a statutory purpose here that holds all supplies that have the same content as 1975 supplies, but in a modern form. Parliament's purpose is to have them zero rated. And the third point I rely on from Talaka is at the end of paragraph 22. In light of the purpose of the EU standstill provision, the content of the national legislation in force in 91 is decisive in ascertaining the scope of the supplies in respect of which the 6th directive allows the zero rate to be maintained.
That all depends on the meaning of the word content.
Yes, and I will, I hope, set out how one determines that. We say that's critical. The shutters came down in 91, or for our purposes, 1975. The content of the zero rate at that time is decisive of its scope. And in my submission, any UK court in 1975 or 1991 fully applying the always speaking doctrine, fully adopting a purposive approach, would conclude that the content of the newspaper provision at the standstill date was printed newspapers and nothing more. And paragraph 23 of Talaka makes the point that it's not just the national provision that you strictly interpret, you also strictly interpret the Article 28 derogation. Now, Talaka is the only case on what it is to extend the scope in zero rating. But there are other cases on what it is to extend the scope, which I will take you to now and rely on by analogy. I'll take the first one relatively quickly, if I may. It's a recent UK decision, a recent decision against the UK in infraction proceedings. You'll note page 261 of the authorities bundle. Now, Article 394 of the directive permitted member states which, on the 1st of January 77, applied special measures to simplify the procedure for collecting VAT as a derogation, permitted them to do so if they notified the Commission by the 1st of January 78. And then there was a procedure to be followed for new measures to be notified. The UK had notified the Commission by the deadline in relation to 11 futures markets, but then made amendments to the national position, adding new markets without notifying them as a new measure. And the UK's position in defence was these new futures markets we've added are substantially the same as the old that we notified. The purpose of the measures that had been notified is what counted, and the purpose was also met by the new markets. For your notes, that's paragraphs 35 and 36. And the CJU said the new measures went beyond the scope of the derogation. And if I could just turn up page 276, paragraph 50. Paragraph 50 and 54 are the important paragraphs. Your Lordships will see in the middle of that the reference to Talika Beach, and at the end of paragraph 50, that conclusion is all the more relevant in a case of markets covering types of transactions which did not exist at the time of the 78 notification. And then at the end of paragraph 54, 4 or 5 lines from the end, that is the case inter alia where markets covering new types of transaction were added, such as in particular transactions involving trade in carbon emission allowances on the ICE futures market. Such additions extend the scope of those derogation measures beyond the items separately identified by the UK and specific justifications given in that regard in the notification. In my submission, the most important case on this question is a case called Metropole, which is in the supplementary bundle. Thank you. Supplementary bundle. Page 31. Sorry, some of my... If I could, just in light of time, summarise the position. This is related to another derogation. Article 17.2 of the directive provides a right to claim input tax deduction. Article 17, subsection 6, contained a derogation. And the question in Metropole was whether the member state had extended the scope of the derogation when it changed its criteria for denying input tax deduction after the standstill date. Now, what Austria had done was it permitted input tax deduction generally, i.e. adopted the standard EU position, but applied a derogation in relation to cars and mixed cars. We don't need to worry about the detail. Derogation in relation to cars. In 1987, circular was issued, which the CJU said counted as law, which in effect defined cars as vehicles which could hold up to 6 persons. The The rest were minibuses and could fall into the standard EU position and deduct input tax. The standstill date in play was the 1st of January 1995, when Austria joined the EU. In 1996, by new regulations, Austria changed its position on what counted as a car. Now, to come within the derogation, cars could hold not up to 6, but now up to 8 persons. Was that an extension of the scope? Importantly, Austria tried to argue, and my lords will see the parallel with our case, Austria tried to argue that the change was made to accommodate new types of cars, people carriers, which didn't exist in 87. Such cars, it was said, could hold up to 9 persons, but still functioned as cars, not minibuses. I could read that important paragraph. It's on page 62. This is Austria's position. With the adoption of the 1996 regs, criteria were fixed for the first time, which were binding both on the courts and on the tax authorities, in order to distinguish minibuses from cars and mixed vehicles. Those regulations were adopted because of the appearance, subsequent to the 1987 circular, of new types of vehicles, such as minivans and MPVs or family carriers, not contemplated by the circular, not to extend the category of vehicles excluded from the deduction scheme, to avoid national legislation in force being interpreted in such a way that those new vehicles, the Pontiac Transport and the Fiat Ulysse, which as a rule take the place of cars, are regarded as minibuses. And the CJEU's answer was clear. Read paragraph 46 on page 65. On the other hand, national legislation does not constitute a derogation permitted by Article 17.6 and infringes Article 17.2 if its effect is to increase after the entry into force of the 6th Directive, the extent of existing exclusions, thus diverging from the objective of the Directive. Note paragraph 47. Finally, interpretation of the national legislation in order to determine its content at the date of entry of the 6th Directive and establish whether the 1996 regs, the effect of the 1996 regs was to extend, after the entry into force of the 6th Directive, the scope of existing exclusions is in principle, as the Austrian government rightly submitted, within the jurisdiction of the National Court. It is, however, for the Court of Justice to supply the National Court with guidance. And dropping to 50, where in a member state deduction of the input VAT paid in respect of certain vehicles was allowed at the date of entry into force of the 6th Directive, the subsequent adoption of national legislation excluding those vehicles from the right to deduct has the effect of extending the scope of existing exclusions. So the new type of vehicles, even though they didn't exist in 87, would not fall within the cars derogation under the the 1987 criteria, and including them in the derogation in 1996 under new criteria counted as an extension of the scope. And we say it's up to the UK, your lordships, to determine the content of the national provision at the standstill date, 1975. But common ground, your interpretation has to be a strict one. Common ground, your interpretation mustn't extend the scope. And we say, when you ask, what were the criteria in the UK for identifying newspapers in 75? If the modern contender would not come within that criteria, including them under new criteria, under my learned friend's proposed criteria, counts as an extension of scope.
I'm sorry, I haven't quite followed what the vehicles, in paragraph 50, the paragraph you were taking us to, which were the certain vehicles for which deduction of input VAT was allowed at the date of entry into force, the relevant vehicles? Were they ones of 7 seats or that?
Up to 6 persons under the 1987 circular and up to the standstill date of 1st of January 95 would be within the derogation. Beyond that, they were minibuses and they fell into the standard EU position. The 1996 regs, to accommodate these new innovations, these people carriers that carried 9 persons but were functionally a family car, extended the criteria to cars being up to 9 persons. And the same point was made in a case called Magura, again dealing with Article 17. It's page 9 of the supplementary bundle. It related to different criteria for fuel. We don't need to look at the detail. The paragraph that is additional in Magura is paragraph 44. Just turn that up. It's page 29. After repeating the points made in Metropole, the court says, and this is common ground, it's for the National Court to interpret domestic law as far as possible in the light of the wording and the purpose of the 6th directive, with a view to achieving the results sought by the latter, favouring the interpretation of the national rules, which is the most consistent with the purpose, in order thereby to achieve an outcome compatible with the 6th directive. And that's why I assume it's common ground that if my learned friend's interpretation extends the scope, it has to be rejected, and your lordships must favour my interpretation, which certainly doesn't extend the scope. And my Lord Burrows asked my learned friend yesterday if on his case it would be an extension of the scope if the UK had legislated to include digital news services in the zero rate, so for example in 2010, beginning of the claim period. My learned friend's response was that it would not be an extension. We say cases such as Metropole and Magura clearly show, whether by legislation or through the always speaking doctrine, interpretation, the adoption of new criteria is an extension. Now, I do this only in case my learned friend seeks to make something of it in reply. There is a case my learned friend has included in the supplementary bundle called Taylor-Wimpey. Taylor-Wimpey considered that a restriction on input tax deduction in relation to zero rates came under Article 28, zero rating, not under Article 17, input tax deduction derogations. And so the court said Magura wasn't in play. But I'm not relying on Metropole and Magura to say that they are zero rating cases. I'm just relying on them by analogy to say, here are cases where the Court of Justice has looked at the question, what is it to extend a scope? I recognise they're input tax deduction cases, not zero rating cases, but they're the closest I could find to guidance from the CJEU as to what it is to extend the scope.
When you said a moment ago that changing the criteria would mean expanding the scope, well, it's changing the definition, but it might actually narrow the scope, mightn't it, if you change the criteria?
There is case law that if you restrict the scope of the zero rating derogation, the EU has no problem with that.
Yes.
It's expanding it that's difficult.
Yeah.
The reason I say that my learned friend's new criteria, as it were, expand the scope is because on my criteria has to be a physical object.
Yeah, I understand.
The content and
yes.
then.
Yeah.
If I could turn then briefly to strict interpretation and what that means.
But if a car, say, before 1987 could have encompassed something which held more than 6 people, it wasn't a problem that Austria restricted it to something with up to 6 people, because that would be a narrowing.
The closer you come to the standard EU position, the happier the CJEU is.
It all comes back to the same question, ultimately. It all comes back to the same question. Is there an extension of content?
But I'm hoping that these cases offer guidance as to what that would be. So turning to strict interpretation, we saw in Talika that a strict interpretation for a zero rate is more strict than for exemptions. Just to note for reference, page 420, paragraph 17, the Advocate General refers to a strict interpretation in zero rating as the need to interpret narrowly. And to remind your lordships, in Talika, the rule against giving a single supply 2 different rates can be ignored in zero rates, even though it's not ignored in exemptions. And we say a strict interpretation, especially in zero rating, means narrow or restricted. Of course, not so narrow as to defeat the purpose in play, but EU exemptions have a different purpose. It's important for EU exemptions, which are mandated across member states, to have a uniform application. That's not the case for zero rates. And my learned friend took you yesterday to the Hadera case. For your note, page 332, paragraph 24, where it was said for exemptions, the interpretations shouldn't be particularly narrow so as to create divergences between member states. In zero rating, there is no uniformity across member states. They are a complete derogation from the EU position. And there's no basis for not interpreting them in a narrow or restrictive way. My learned friend mentioned the Court of Appeal decision in Expert Witness yesterday, where it was said that a strict interpretation is not the most narrow or the most restricted. And if a supply comes within a fair reading, then that would be fine. But that was said in relation to exemptions, not zero rates. And we say that that language has not been used by the CJEU. The CJEU consistently refers to a strict interpretation, and we say that must mean something different from, well, if it's in a fair reading of the provision, that's sufficient. In any case, we say including the digital news services in the newspaper provision is not even a fair reading of the provision, it's an expansive interpretation, which certainly is not permitted. To give your lordships the most recent and very short example of a strict interpretation, it's in a case called BAG from February 2022 at page 83. We don't need to turn it up. 83.
83.
It's a very short point. It concerned the meaning of wood for use as firewood, which can have a reduced rate under Article 122. And the CJEU said that wood for use as firewood on a strict interpretation meant wood exclusively for use as firewood. So we say that's a small example of how a strict interpretation must be a narrow one. If wood can be used mainly for firewood, but also for, say, wood carving, on the CJEU's interpretation, it's not within the provision. It has to be exclusively for. And to turn to the final part of my submissions and deal briefly with fiscal neutrality, if I may. I deal with it briefly because my learned friend's submissions made clear there is now a lot of common ground between us. First, my learned friend accepts that an issue of fiscal neutrality certainly cannot be a basis for extending the scope of the zero rate. And there's clear authority for that proposition. My learned friend took you to Deutsche Bank. And I just want to turn it up briefly because it's actually helpful on what is a strict interpretation as well. So, to remind your lordships, the case again concerned a single composite supply issue. But here, the standard rated and the exempt elements of the single supply were on an equal footing. So no principal and ancillary, they were on an equal footing, 50-50.
Have you got a page reference for us?
Yes, it's page 323. Yes, the paragraphs I'm going to go to in a moment are on page 323.
Thank you.
But the head note starts at page 300, my lord. So it was a 50-50 equal footing of the two elements, and the court had to decide which of the two elements would characterise the single supply. And if we pick it up at paragraph 41, it is apparent from paragraph 27 of this judgment that it's not possible to regard the elements of which that service consists as constituting a principal supply on the one hand and an ancillary service on the other. Those elements must be placed on the same footing. In that regard, it is established case law that the terms used to specify exemptions are to be interpreted strictly, since they constitute exceptions to the general principle that VAT is to be levied on all services supplied for consideration. 43. Consequently, since that service may be taken into account for VAT purposes only as a whole, it cannot be covered by 1351F of the directive. Dropping down to paragraph 45, it must be stated that that conclusion is not called into question by the principle of fiscal neutrality. As the Advocate General stated, that principle cannot extend the scope of an exemption in the absence of clear wording. That principle is not a rule of primary law which can condition the validity of an exemption, but a principle of interpretation to be applied concurrently with the principle of strict interpretation of exemptions. But what happened in that case? You start off on an equal footing. Not only does a strict interpretation have a narrowing effect on making the exempt element less significant, but the fiscal neutrality principle doesn't act the other way to bring the single supply back into the exemption. For your Lordship's note, the case of État Belge, authorities, page 171, paragraphs 31 to 32, and the case law cited there, including the Luxembourg case, which is at page 249, all make the point, and it's common ground, fiscal neutrality cannot extend the scope. And that shows, we say, that even if my learned friend establishes his case under the always speaking doctrine, if he cannot show that his interpretation doesn't expand the scope, fiscal neutrality cannot help him. As I understand that, it is common ground. And if my learned friend does establish his interpretation under the always speaking doctrine and shows it's not an expansion of the scope, hard to see why fiscal neutrality would be needed. Now, perhaps I misunderstood, but my learned friend sought to say that fiscal neutrality may still be relevant. He says if he fails on the genus of fact, same kind and dimension aspect of the always speaking doctrine, fiscal neutrality can't help. That has to be right. If he fails on that basis, he hasn't passed the always speaking doctrine, and if you try and bring those services in, you've certainly extended the scope, because they don't even come within the meaning. The way in which my learned friend says fiscal neutrality might still play a role is, as I understand it, if your lordships find that, for example, the e-reader PDF version, which only has the search function and not the links into wider and different content, if he wins on the basis that the e-reader is 0 rated, but the rest are standard rated, then my learned friend says he can appeal to fiscal neutrality in relation to smartphone, website, or tablet editions. He must mean as long as doing so does not extend the scope. But of course we say, including these digital news services, in such circumstances would certainly extend the scope, because on this hypothesis your lordships have found, despite the vigour of the always speaking doctrine, that these things are not in the meaning of the national provision. Your lordships bring them in under fiscal neutrality or on any other basis, you're necessarily extending the scope. And just to deal with one final case that my learned friend mentioned, the sub 1 meatball marinara case. And I'm not sure I understand what my learned friend seeks to take from this case. There, the meatballs and their competitors were all out of the zero rate on the basis of the correct objective test.
Could you remind us of the reference to the case?
It's around 916, sorry.
406 was the reference Mr. Peacock gave us.
Thank you.
The head note is at 885, yes, thank you. So the meatballs and their competitors were all out on the basis of the correct objective test.
I apologise, I can't remember. Page must be wrong.
Oh,
I think it must be 906.
906.
sorry, I'm just to make sure by looking at my paper.
Yes. That's right. Mr. Peacock said 406 and then changed it to 906, and
Yeah.
my note had made the same mistake.
So head note at page 885. Both sub-1 supplies and the competitors were out of the zero rate on the correct objective test. What had happened, though, is that the competitors' supplies had in the past wrongly been given the zero rate because the courts had consistently applied the wrong test, a subjective test of whether food was hot or not, or intended to be eaten hot. So the two were in the same national category in the sense that they were both standard rated outside the zero rate. And sub-1's complaint was, the complaint from fiscal neutrality, how if we both fail on the right test and we're both in the same standard rated category, can my competitors have the benefit of the zero rate while I cannot? That was the complaint from fiscal neutrality sub-1 is making. And the Court of Appeal's answer to that question is at page 916, paragraph 90. The answer that had already been given in a ranked case: taxpayers cannot demand to be given the wrong treatment on the basis of fiscal neutrality. So if there's been an error by HMRC or the courts and somebody has been given zero rating wrongly, one can't demand on the basis of fiscal neutrality that it also receives the zero rating wrongly. But that's not this case. I don't say that my learned friend can't, in principle, look to fiscal neutrality, but only if he can show that doesn't extend the scope. My learned friend's only reason to look at fiscal neutrality is because he's failed on meaning. These aren't newspapers, but they compete with newspapers. Shall we try and get them in? CJU's answer is you can't. That would extend the scope. If they're not within the meaning, you must be extending the scope.
But do you say it can't be taken into account in ascertaining what the meaning is as well?
Yes.
It's not relevant, you say, that two items are commercially interchangeable for in ascertaining the meaning?
One can't decide if something is a newspaper by deciding the competition question. And once one decides it's not a newspaper, including it in the zero rating provision for fiscal neutrality reasons or anything else is necessarily an extension of the scope. My Lords, if I could just take 1 second.
Yes.
My Lords, those are my submissions. I just want to hand up the explanatory note and explanatory memorandum for the 2020 UK changes, because I said that I would hand them up yesterday. I don't need to make submissions on them, but they show that the Viries, UK Parliament considered the Viries came from the 2018 directive. It's just really two paragraphs. 6.2, the European Union Viries for these changes are contained in the 2018 directive, which made changes to the EU's optional reduced rate provisions. The directive came into force in December 2018. Dropping to paragraph 7.4, the exclusions are e-publications that are wholly or predominantly devoted to advertising or to audible or video content. Exclusions for audible music and video content are necessary to comply with the Viries in the 2018 directive.
What exactly is the status of this document? Can you just explain? It's not the ordinary sort of explanatory note that accompanies a legislation.
No,
something different from that, is it?
Yes, it's the. It says at the top, explanatory memorandum has been prepared by HMRC on behalf of Her Majesty's Treasury and laid before the House of Commons by Commander for Majesty. And it sets out, I think, the
It's a briefing for the Select Committee on Statutory Instruments, apparently.
I'm told it's required for implementing legislation, but I'm not trying to base my submissions on this. It's just I gave the information yesterday that the explanatory memoranda referred to the 2018 directive, and I'm handing it up on that basis, but I'm not seeking to rely on it beyond that. My Lords, are there, my submissions are finished unless your Lordships have further questions for me. I have a little bit more time if your Lordships do.
No.
Thank you very much.
Thank you.
Mr. Peacock.
Well, I'll start with the questions of UK statutory interpretation. To reiterate a point I made yesterday in opening, it is not our case that any supply that meets the particular social purpose here is or should be zero rated. This is a necessary requirement satisfied here, but it is not sufficient. Equally, that Parliament makes hard choices to zero rate one thing and standard rate another is, fiscal neutrality aside, a matter for Parliament. Similarly, not all supplies that promote literacy, for example, are zero rated. All of that is true, but it doesn't address the relevant question. come to that in a moment, but just in that connection, my own friend showed your lordships the Barker and Wilson always speaking case about bankers' books. That's a perfectly good example of an application of the always speaking approach to meet the requirements of new technology, where the purpose of the provision and the use of the relevant term in context required the extension of the interpretation of bankers' books. But it is no more than that. It's a perfectly good example of the approach that the courts will, in appropriate cases, take. As my Lord Hodge put to my learned friend yesterday, one cannot generalise about the scope of zero rating or standard rating. One has to look at the words that are used by Parliament in context, an observation which we would endorse and accept. Well, my friend then said, well, Parliament might treat different items in the same genus differently. And of course, it might do so. But in order to decide whether it has done so, one needs to see the relevant term in context in light of the particular purpose. In that regard, my own friend sought to draw some support from areas where Parliament had not legislated to address new developments, where it might be thought Parliament was aware of such developments. But with respect, one cannot draw any relevant conclusions from Parliament's failure to legislate in a particular field. That may or may not be a conscious policy choice made by Parliament. We just don't know, and one should not speculate. Against that background, my learned friend's main submission, indeed perhaps when all is boiled down her only submission on UK statutory interpretation, is that newspaper is necessarily limited to a tangible printed item. That submission, we say, rests on false logic and is not supportable as a proper interpretation of Group 3. It rests on false logic that because Parliament can only have had printed newspapers in mind in 1972, therefore Parliament determined that zero rating should be limited to such newspapers, whatever technological developments may come along later. We say that does not follow at all. Equally, it's not supportable on a proper interpretation of Group 3. Pausing for a moment, the exercise in statutory construction is necessarily an iterative exercise, taking account of the purpose of the provision, the words used, and the context in which they are used, and then against that background, appreciating the relevant characteristics of the item to be tested in the given statutory provision. Now, here we know the purpose, we know the word used, we know the context where there is no express reference to print or tangible form or goods. Against that background, what are the relevant characteristics of a newspaper? Now, that exercise, we say, has to be informed by the purpose. That purpose is the promotion of literacy, the dissemination of knowledge, and encouragement of democratic accountability. Those goals are concerned with content and not form. They lead to the conclusion that an edition-based, periodically produced, curated news and comment is and should be the relevant characteristics of a newspaper. Specifically, it was no part of the purpose to promote the print industry. There is nothing to that effect in any materials. It's not in Hansard, it's not in explanatory notes, it's nowhere. Given that that is no part of the purpose, the form of a newspaper, tangible or intangible, services or goods, broadsheet or tabloid, with pictures or without, none of those are relevant characteristics. Now, it is the case that the man or the woman on the proverbial bus in 1972 may well have said that a newspaper had to be printed and made up of folded pages. But with respect, that's not the relevant question. The question is, how should that term be understood here in 2010 through to 2020? And of course, we know now that newspaper titles are made available digitally, indeed, in some cases, only digitally. So what was the independent newspaper, now the newspaper, is only available online. We have an example even in this case. The Times on Christmas Day is only available digitally. But that is just as much a newspaper for zero rating purposes as is the edition on Christmas Day. So turning to Always Speaking, my friend accepts that it can apply to zero rating, but objects that it does not here, because the digital editions are not the same genus and do not meet the same purpose. But in each case, her only reason for such conclusions is that newspapers have to be tangible. And if my learned friend is wrong about this, and we say she is, there is then no barrier to the application of Always Speaking. Now, so at this point, my learned friend offered the example of the robotic dog. It's interesting because dog is the one thing that Lord Bingham believed could be the subject of Always Speaking in Quinterval. It's a matter for another day as to whether a robotic dog would be included, but it is important to note my learned friend misremembers paragraph 9 of Quinterval. His lordship does not say that other types of dog might constitute dog for some statutory purpose, but other types of animal, by recognising that they didn't have to be the same genus. Be that as it may, we say there's nothing in the statements of principle in Quinterval, or indeed any of the other Always Speaking cases, that would require or allow this court to conclude that the Always Speaking approach is not applicable as regards this zero rating. My Lord Burroughs put to me yesterday an opening observation that my learned friend picked up, is in applying the Always Speaking approach, one must take account of all changes since enactment, including later legislation. Now that would here, for most but not all of the relevant period, include the 2011 note. That note related to an anti-avoidance provision, which operated in certain circumstances not material here, and does not throw any light, we say, on the proper interpretation of newspaper. But that approach of looking to later changes, including legislation, might be said to include item 7, introduced in May of 2020, and effective only after our relevant period. It might be said in construing newspaper, one must take account of all relevant legislative developments, perhaps so as to address the statutory scheme as a coherent whole. Here we would say not so. The later edition of item 7 with effect from May 2020 cannot affect the purpose of interpretation of newspapers prior to May of 2020, both as a matter of logic, so as to avoid a breach of the standstill, and not least for the practical reason that one can't wait until 2020 to decide one's tax position in 2010. Now, to give a practical example of this line of thinking, imagine a case where we're concerned with the classification of something or some person in a period 1990 to 2000. And we have an Act of 1925. Now, if there's some later amending Act in 1985, that later Act can't cast light on the purpose of the 1925 Act, but it does form part of the statutory scheme as a whole, to which a coherent approach must be given in the 1990s. And if that later Act were not in 1985 but were in 1995, that need for a coherent approach would operate at least for part of the relevant 10-year period. But if that later Act is in 2002, there is no basis upon which to take it into account. And here we are, this latter case, because item 7 is only effective from May 2020 2020 onwards, and thus outside of our relevant period. So yes, one can look to purpose, one must look to purpose, but item 7 cannot form part of any coherent whole to which effect must be given in our relevant period. I made my observations in opening, which I don't repeat unless it would help your lordships, as to the effect of item 7, and in particular 7A and 7B, but it is important to note that what the draftsman has done in item 7 is to assume that a newspaper can be produced digitally, because what is zero rated is a publication in items 1 to 3 that's produced digitally, but then carved out from zero rating, and importantly, not altered the definition of newspaper, certain types of publication. Now, for what it's worth, you've heard a lot from my own friend about the revenue policy, so we looked up the revenue policy here, and the revenue policy from 2010 onwards was that publications which did not contain a substantial amount of news are not newspapers. So the exclusions that you see in 7A and B are reflective of the revenues policy and align with a conclusion that those items were not newspapers in any event.
Have you got any references to support that?
We don't have a copy, Muller, but it's the revenues notice 701/10 in force from 2010.
You,
Need be, we can provide a copy to the court by email. So we say there's nothing in item 7 that bears relevantly on the question of statutory interpretation.
Can I just ask you before you move on from that, a lot was made of the fact that maps have not been extended by that provision. I realise that you may wish to simply say, well, maps aren't what we're concerned with today, but it would seem to me that by analogy, if we were to accept your arguments today, it would be hard to deny that electronic maps were also included, and then I think you would have to say, well, how would you then deal with the submission against you that's been put in relation to the 2020 reform?
My Lord has anticipated my first answer is we're not concerned with maps, we're only concerned with newspapers. My second answer is a refinement of that, is that we do now have the benefit of the consideration below, both on the facts and then the legal argument, as to what are the characteristics of a newspaper. And there's a debate between us, and one of us is right or wrong about that, but you have the benefit of that. There has been no discussion below as to the characteristics of a map, nor whether a map necessarily has to be printed. One could think of a map being in globe form. It's not printed, it is a physical item, but it's very difficult to reason by analogy from another category in Group 3 and then read that category in light of a change that was or wasn't made in item 7 and then use that as a foundation to draw conclusions about the scope of newspaper. That would not be a sound basis upon which the court should arrive at a decision in this appeal in our submission. There may well be litigation in future as to whether I have access to the Ordnance Survey on my phone on a walk. That is a map. But that case will have to await for somebody to pursue that point. So you'd heard from my learned friend this morning, she was asked about purpose, and she said purpose can't help. It's not a good guide. Not a guide at all, I think she said. We disagree fundamentally. One has to construe the term used in light of the context and its purpose. And my learned friend was then driven to say, I think I understood her, that a print book is zero-rated, an e-book is zero-rated, but a book on CD-ROM is standard-rated. Now, she has to say that because of her rather convoluted reading of the 2018 directive and its effect. But again, it's not a necessary part of my case that she's wrong, though I think she is. But we're not here arguing about books and e-books. That, again, may have to wait for some later litigation. And there was a strong hint that too much of my own friend's case, in answer to your Lordship's observations, was driven by revenue policy and not by what the law is. And next, Lord Hodge suggested to my own friend this morning that Parliament knew that it was making policy choices in compliance with the second VAT directive in advance of our joining what was then the EEC and pending a fully harmonised system. My Lord, I would say that must be right. That's what Parliament was doing. But compliance with such EU parameters, i.e. Article 17 of the second directive, and in knowledge that there was planned to be eventually a harmonised system, brackets which still hasn't arrived, is not a basis on which to exclude, as a matter of principle, the application of always speaking to the terms that were used by Parliament in 1972. My Lord Burrows had to say this morning to my learned friend, there's also no help here in some a priori classification of terms as flexible or liberal or permissive or inflexible. All one there is really doing is restating the conclusion one's about to arrive at. One has to decide instead the relevant application of always speaking in light of the terms and context and purpose. There then followed a debate with my learned friend as to whether there was any basis on which all editions would be zero-rated or whether some of them would be. We had that debate below in the first tier. Since then, our case has been that all editions are zero-rated, and the Commissioner's case is that none of them are. But significantly, the first tier found as a fact that all of the digital editions were fundamentally the same as the print. Well, the friend then briefly took your Lordships to the Court of Appeal's paragraph 69, key documents, page 87. I said in opening, I'll simply restate that our answer to that paragraph is in our written case at paragraph 26, key documents, pages 24 through to 27.
24 and?
To 27.
27, thank you.
And then lastly, I think under this heading, my learned friend observed that we were not saying that one should give effect to our reading of newspaper so as to give effect to the purpose here. And we are saying that in the modern world, to use the language in Victor Chandler, it would seriously undermine the purpose of the zero rating if the zero rating is not extended to digital editions of the newspapers. So those are my observations in reply on the UK statutory exercise. I turn then to EU law. It is common ground that there is a requirement for strict interpretation, but one needs to bear in mind what that means. We looked in opening at what my Lord Kitchen had to say in SAE education and at what the European Court has had to say in Hadera. I stand by those. My learned friend was minded to move the language she used from strict to narrow to restricted. That sliding or elision of language, we say, is not permitted on the authorities. One has to go back to what this court had said in SAE and what the European Court had to say in Hadera.
Do you accept her point that there's a difference between EU exemptions and national exemptions, in that there's a reason to interpret EU exemptions in a consistent way, but not in the case of national exemptions, because any national exemption derogates from a harmonised scheme?
That, my lord, is true, yes, I accept that. But I think my learned friend was making a slightly, well, maybe an additional, more nuanced point, that one had to take a strict approach to EU exemptions because they depart from the standard rating norm. And she was trying to suggest the authorities established that one should take an even stricter approach to derogations because they are one step further away from the norm. But with respect to my learned friend, that's not what the authorities actually say. If one looks in the Advocate General, it's page 424 of the authorities, he simply says one needs to take particular care when one is concerned with a derogation. He doesn't express it in the language of even stricter. And the B and AG case dealing with wood takes the matter no further. There's no statement of new principle in that case. It was about wood that you might use in one way and might use in another. So it's a perfectly good example, but it doesn't advance the principle. So yes, this court is required to give strict interpretation, but we know what that means. My own friend also then said, as a matter of broad principle, that one can't extend, and the way she put it was, beyond the 1975 barriers, or the 1975 borders. She put it just a few minutes later, the content in 1975 is decisive of the scope of the zero rating. That's not what the Court of Justice say in Talaka. In particular, I remind your lordships of Talaka at paragraph 16.
Just give us a page again, please.
Yes, it's paragraph 16, my lord, and it is pages 426 and 427, where the principle is correctly expressed, we say, as not permitting the extension of the zero rating beyond the terms specifically laid down by the national legislation. Now, that formulation rightly does not prohibit interpretation of the given term in order to conclude whether product A is or is not within the zero rating. An exercise of interpretation is not necessarily an extension of the zero rating category. And of course, to bear in mind here, my learned friend's case, again, is that this is an extension, but only because, on her view of the world, newspaper is always to be limited to goods, the physical, the tangible, the print. So we say a proper reading of paragraph 16, indeed paragraph 16 through to paragraph 23 of Talaka, is that one looks to the content of the national legislation and interprets it, and then one has to form a view whether the application of that term or that language to a given state of affairs is an interpretation of the provision, brackets permitted, or an extension of the provision, brackets not permitted. And that is exactly the point that is made in the first tier tribunal in the Harrier case, in particular, it's paragraph 66 in Harrier. page 615. And it was at that point, I think, my Lord Burrows asked whether the European Union law has an always speaking concept. And our understanding also is not in such terms, but of course European law does have the teleological approach to the treaties and the directives, which will commonly come to the same place, but I cannot say it is the same. Now, in the connection with the EU position, where my learned friend was trying to exemplify what it means to extend an exemption or a zero rating, he gave you 3 examples. The first was the Commission against the UK case. Page 261 is the headnote. And it is here just worth turning this up briefly to see what was going on there and why this is a perfectly unsurprising result. So this concerned the terminal markets, so markets in London whereby different types of goods and financial instruments were traded. And for various reasons, the UK had to notify the particular markets as a derogation from EU law. And so when we joined the EEC in 1973, we notified 10 markets. That's page 267, paragraph 13. They're listed there, from metal exchange down to the Liverpool barley futures market. There were 10 of them. In 1975, we dropped one out and put new ones in, 2 new ones in, so there were 11. That's page 267, paragraph 14. And that was the position at the time of the 6th directive in 1977. Thereafter, we added 6 more, added 2 more and then removed them, and then removed 1 of the original 11. That's page 268. But the upshot of that is that after the 6th directive came into force, the markets to which we said this special treatment applied were simply different. They were different markets trading different instruments or different commodities. So the answer in that case was obvious. The UK was in breach. Equally, the Metropole case about the input tax block is in the supplementary bundle of authorities at page 49. Again, there were very different categories of item that did not fall foul of the block. So if one compares paragraph 12 on page 55, which was the 1987 notion of a minibus, with the later notion of a minibus, which is paragraphs 16 and 17 on pages 56 and 57, they were simply different. In Austria, they'd moved from all minibuses as defined are outside the input tax block, such that input tax can be recovered, to a world in which very specific types of minibus were outside the input tax block. And that was clearly a case in which Austria had changed the category to which this special treatment applied. And it's no surprise that the European Court would conclude that changing the categories amounted to an extension. With respect to my own friend, the answer to our present appeal does not depend upon a close comparison of the Austrian definition of a minibus between 1987 and 1991. It's a perfectly good example of the principle your lordships are concerned with, but it does not take this appeal further. What is interesting for our purposes about Metropole is paragraph 47, which my learned friend showed to you, page 65, which makes clear that the interpretation of a term to see whether it amounts to an extension is a matter for the National Court, thereby making clear the divide that we see as a matter of principle, that interpretation of a term does not automatically amount to extension. The only part of Magura that is part of Metropole that is really relevant to this appeal, we say, is paragraph 47. The rest of it's a perfectly reasonable example of the application of these principles. My friend also mentioned Magura, and I don't think she indicated that it really added anything to the debate. For our part, we would agree. She also mentioned Taylor-Wimpey, which we had put into the supplementary bundle, but it was there to explain the relationship between the UK's zero rating and exemption with a right of refund, and I don't rely on it for anything else. So we say, as a matter of principle, when one comes to EU law, if this court were to conclude as a matter of UK statutory interpretation that newspaper does apply to a digital edition, that thereby is not necessarily an extension of the zero rating, and here we say, on the facts, it is not an extension of the zero rating. Still, whilst dealing with European law, my learned friend handed up the explanatory memorandum to the change that was made in May of 2020. And she is right, and I'm afraid I had forgotten that paragraph 6.2 refers to the 2018 directive. But there is a discord between the explanation that is given in this memorandum and what's actually in the directive. So if you have that to hand but could turn up the directive itself, which is page 22, and it's recital 3. Recital 3 is doing the two things I identified in opening. It's allowing member states to introduce a new reduced rate for the supply of books, newspapers and periodicals, irrespective of whether they're supplied on physical means of support or electronically. And then secondly, about 6 lines down, it's allowing member states that already apply VAT rates lower than the minimum, or that grant exemptions with deductibility of the VAT paid at the preceding stage, to certain books, newspapers or periodicals supplied on physical means of support, to apply the same treatment to electronic editions. But that is couched in the language of member states that already do that for items on physical means of support. And that is the effect of the changes that are made by Article 1 over the page on page 23. What is said in paragraph 6.2 of this memorandum is that the directive dealt with member states that already had a reduced rate or an equivalent zero rate for supplies of printed publications. So for our part, we do not regard as a matter of law 2018 directive as being the necessary vires for the change that was made in May of 2020. And there is another oddity about the directive itself. I'm not sure whether I mentioned this in opening, but we should just note it. What is amended by the directive is Article 99, and that deals with super-reduced rates. And the amendment that is made is to purport to add to Article 99 a provision dealing with zero rating or exemption with a right of refund. So that's an addition of a provision about zero rating of certain items to an article that's not concerned with zero rating. Now, we do not know why that is. One can infer that there's some political accommodation in the European Parliament or the Commission or both that regarded that as an appropriate change in the circumstances. But there is nothing in the directive itself, we would say, which leads to a conclusion about the scope of item 7, which this court could then rely upon to inform its interpretation of newspaper in the period before item 7 came into force. That would then take me to fiscal neutrality. My friend rightly states it's common ground between us that fiscal neutrality can't extend to zero rating, and we've both taken you to Deutsche Bank. What she seemed to step away from was the notion that fiscal neutrality was not a principle of interpretation, whereas quite clearly on the authorities it is. And it's a principle of interpretation that has to be applied concurrently with the notion of a strict interpretation of an exemption, or here a zero rating. And that was the point we were making by reference to the sub-1 authority, where Lord Justice McComb, in particular at his paragraphs 60 and 64, makes the point that interpreting a term is not necessarily to extend it. Instead, one has to determine whether one is being invited to apply the principle of fiscal neutrality so as to afford equal treatment of items within the same category, brackets permitted, or to provide for the same treatment of items not in the same category, not permitted, because that would thereby be an extension. Now, the case, as your lordships had from me in opening, is that fiscal neutrality necessarily is one of the principles of interpretation that has to be factored in this statutory interpretation exercise, but that there may be a world in which I have lost on issue 1, where I may need to rely upon issue 2. In those circumstances, my case is that I am entitled to do so, but doing so here doesn't amount to an extension. So Lord, we come back ultimately to Lord Simon and Frank Jones. Is a newspaper capable of meaning X or Y, so including or not including digital editions? Well, as a matter of statutory construction, the answer is yes, and we know the first tier in the Court of Appeal thought one and the upper tribunal thought the other. Do we know the purpose of the provision here? Yes, it's been done to death. Does that purpose show that a meaning including the digital editions should be given to the word newspaper? We say yes. Is that then in accordance with European law, in that it does not offend strict but purposive construction and does not amount to an extension? We say yes. Lord, unless there's anything else I can help the court with, those are my submissions in reply.
Thank you very much, Mr. Peacock. Well, the court is very grateful to counsel for their submissions, their careful submissions in this interesting problem. The court is also grateful to those who assisted counsel in the preparation of the submissions and in the preparation of the papers, both physical and electronic, on which we are relying. The board will produce a judgment, I hope, within a reasonable time, and will now adjourn. Thank you very much.